Was passiert, wenn Sie nachts auf einem Spaziergang von der Polizei angehalten werden? Genau das werden wir heute besprechen. Los geht's!
It is 11 p.m. You are walking home. A police cruiser slows beside you. An officer steps out and says, "Hey, stop, I want to talk to you. You have done nothing wrong." You know that. The officer does not know that yet. And in the next 60 seconds, almost everything you think you know about your rights is going to be tested. And most of it is going to fail. Here's the thing nobody tells you before it happens to you. The fear you feel in that moment is not irrational. It is not paranoia. It is not you being dramatic. It is your body correctly reading a situation where the rules are much more complicated than you were ever taught, where the law on paper and the law on the street are two completely different documents, and where the wrong move, even a legal move, can make everything worse. What if I told you that walking away from a police officer who has not arrested you, which feels like it should be your right, can actually give that officer more legal justification to chase you, stop you, and detain you? Not less, more. That is not a loophole. That is Supreme Court precedent, and it has been the law of this country since 1968. So let us talk about what actually happens when police stop you walking at night in the United States. Not what the civics textbook says, what the courts have actually decided, and what you need to know before it happens. Because if you wait until it is happening, it is already too late to think clearly. You probably feel confident right now. You have heard the phrase, know your rights. You have maybe watched videos. You think, I will stay calm. I will not answer questions. I will invoke my rights. You have a plan. Here's the problem with the plan. The plan assumes the stop is already legal. It does not tell you what happens in the 30 seconds before the stop, when the legal framework is still being assembled around you in real time. Let us start there. The legal foundation of every police street stop in America is a 1968 Supreme Court case called Terry v. Ohio. A Cleveland detective named Martin McFadden watched two men walk back and forth in front of a store roughly 24 times. He thought they looked like they were casing it for a robbery. He had no warrant. He had no probable cause. He stopped them, patted them down, and found weapons. The Supreme Court said that was fine. Under what the court called reasonable suspicion, a standard far below probable cause, far below what is needed for an arrest. An officer can stop you on the street, detain you briefly, and in some circumstances pat you down for weapons. The lone dissenter, Justice William Douglas, wrote that this gave police more power than a judge. He was right, and that decision has never been overturned. This is the thing. The Fourth Amendment says you are protected from unreasonable searches and seizures. Most people hear that and think, I am protected. What the Terry decision did was move the definition of unreasonable, and it moved it a long way. So when an officer stops you at night, they do not need to have seen you commit a crime. They need to be able to articulate specific facts that, combined together, suggest criminal activity might be happening. That is it. Specific articulable facts. Courts have upheld stops based on being in a high crime area at night, walking away from police, making eye contact, not making eye contact, wearing baggy clothing, running, wearing a hoodie. In 2000, the Supreme Court ruled in Illinois v. Wardlow that running from police in a high crime area is a factor that contributes to reasonable suspicion, which means if your instinct when you see police is to move away, an instinct the court itself acknowledged may be completely innocent, that instinct can be used against you. You are not free to leave a Terry stop. That is the part most people do not understand. If a reasonable person in your position would not feel free to leave, and when an officer has stopped you and is speaking to you, you would not, then you are legally being seized. Leaving anyway is not exercising your freedom. Courts have treated it as flight, and flight triggers more suspicion, not less. So what do? You stop, you stay, and you say calmly, out loud, am I being detained or am I free to go? If the officer says you are free to go, you go calmly, without running, without turning back. If the officer says you are being detained, you say this: I am invoking my right to remain silent. I will not answer questions without an attorney present. Then you stop talking completely. You do not explain. You do not justify. You do not narrate your evening. You are not rude. You are not aggressive. You are simply finished speaking. This is not a tactic. This is the Fifth Amendment, which protects you from being compelled to be a witness against yourself. But it only works if you actually use it. Silence alone is not enough since 2013. In Salinas versus Texas, the Supreme Court ruled that if you have not been arrested and you have not explicitly invoked your Fifth Amendment rights, your silence can be used against you in court. You have to say the words. Now let us talk about the frisk, because this is where people make mistakes that change everything. If an officer asks to search you, and they often do, you're allowed to say no. You say, "I do not consent to a search." Clearly, calmly, once. You do not physically resist. If the officer searches you anyway, that is a Fourth Amendment issue your attorney handles later. Your job in that moment is not to win the argument on the street. Your job is to survive the encounter and preserve your rights for the courtroom. There is a legal mechanism called the plain field doctrine, established in Minnesota v. Dickerson in 1993, which says that during a lawful pat-down for weapons, if an officer feels something that is immediately apparent as contraband, they can seize it even without a warrant. The limits of that doctrine are real, but they require a lawyer to enforce them, which is why the only thing that matters in the moment is that you did not consent, you did not resist, and you said the words. Now here is something the law does not protect you from, and no attorney will tell you differently. The encounter can go wrong even when you do everything right, and in America, that reality falls hardest on black men. In New York City, between 2003 and 2013, the NYPD conducted over 5 million Terry stops. The Center for Constitutional Rights documented this. 83% of people stopped were black or Latino. 88% were innocent. The program was called Stop and Frisk. In 2013, federal judge Shira Scheindlin ruled in Floyd v. City of New York that the program violated the Fourth Amendment and the Equal Protection Clause of the 14th Amendment, because the stops were based not on individualized suspicion, but on the color of someone's skin. The city did not appeal. The program was reformed, but the Terry doctrine itself was not touched. The legal mechanism that made 5 million stops possible is still there. It just has to be used differently now, at least in New York. In other cities, different story. The enforcement gap between paper law and street reality varies dramatically by department, by precinct, by shift, by officer. There is one more thing you need to understand about the night stop, and it is the thing nobody puts in the video. The thing that makes everything else make sense. You may exercise every right perfectly. You may say the exact right words in the exact right order, and the stop may still go wrong. The reason the legal protections matter is not because they guarantee safety in the moment. They do not. They matter because they are the difference between what happens to you on that street and what happens to you in that courtroom. They preserve the record. They give an attorney something to work with. They are not a shield. They are documentation and exact right words in the exact right order, and the stop may still go wrong. The reason the legal protections matter is not because they guarantee safety in the moment. They do not. They matter because they are the difference between what happens to you on that street and what happens to you in that courtroom. They preserve the record. They give an attorney something to work with. They are not a shield. They are documentation, and documentation in a courtroom can be the difference between a conviction and a dismissal. Here are the 3 things you do if you are stopped walking at night in the United States. First, the moment you feel you cannot walk away, you ask, "Am I being detained or am I free to go?" You say it once, you say it calmly, you do not ask anything else until you have the answer. Second, if you are being detained, you say, "I am invoking my right to remain silent. I will not answer questions without an attorney present." Then you stop talking. Not mostly, completely. The Fifth Amendment only works if you say those words. Silence alone is not enough. Third, if asked to be searched, you say, "I do not consent to a search." You do not physically resist. You let the record reflect your refusal. That record is what an attorney uses later. Never let the street be where you try to win. If this changed how you see what knowing your rights actually means, there is one book I would put in front of you next. It is called Chokehold by Paul Butler, a former federal prosecutor, published in 2017. Butler does not write about policing from the outside. He prosecuted cases. He watched the Terry Doctrine in operation from inside the system. Chapter 2 of that book takes the reasonable suspicion standard apart phrase by phrase and shows you exactly how a legal tool designed to protect communities became something else entirely in practice. It is not comfortable reading. It is necessary reading. Find the link in the description at the top of the box. Here's the question I want you to think about before you answer in the comments. Not, what do you think about police stops? That is too easy. Think about the last time you were in a public space at night, a parking lot, a train platform, or a street corner, and you saw police nearby and you felt something, not thought something, felt something. What was that feeling and why did you have it? Write that answer. I am genuinely curious. The Terry Doctrine has been the law for 57 years. Not one president, not one Congress, not one Supreme Court has overturned it. Every city that reformed its stop and frisk program did so while leaving the legal foundation completely intact, which means the gap between the rights you think you have and the rights you can actually use at 11 p.m. on a street with no witnesses. That gap is not an accident. It was designed. And the first step to navigating it is knowing it exists. If this changed how you see something, there is more. Subscribe.
Das für heute. Weitere Informationen finden Sie in diesen Videos. Klicken Sie einfach darauf. Das für heute. Weitere Informationen finden Sie in diesen Videos. Klicken Sie einfach darauf.